Everybody, welcome to the Senate Judiciary Committee. I'm going to ask our pro temp, who will please open us up in a word of prayer. Are you Mike 12?
Yes, Mr. Chairman, number 12. Thank you. And good afternoon. Let us all bow. Heavenly Father, thank you for another day that you've given us. Thank you for the opportunity to be here and serve. Please bless all of us, those that are trying to make good decisions, and all of those decisions, those that will be affected by those decisions. Heavenly Father, please be with first responders and our police and all those that are making sure that we're safe in the most critical times when we need it. In Christ's name, amen.
Thank you. If you want to be heard on a bill, please come sign up on one of the sign-up sheets up here in the front. And I will say this to our committee. I was in the House subcommittee of Judiciary today at 1:30 for a bill. So I went down about 1:20, and they started, and in their defense, it was Russ Goodman, started with a bill. I then went back upstairs and presented a bill at 2 o'clock in the committee, came back down, they're still in that first bill. And then I went back over here across the street upstairs and presented a bill, another House committee at 3, went back, and they were still on that bill. Then they did move it out, and I got to present my bill closer to 4 o'clock. So if you think we take forever, y'all know the House is still much slower. But again, in their defense, think about who had the bill over there. So anyway, we'll try to be a little faster, and we appreciate all the work y'all are doing. Y'all brought us a bunch of bills. We'll try to be a little quicker this evening, though. I was joking with three of y'all. I had 3 different requests for people to go first with great excuses, and I landed on the best excuse was Senator Setzler has a substitute on one of these bills, and he has a flight. He's got to leave here at 5:30, he says. So we're going to start with that bill. We're going to be all out of order. House Bill 1017, third from the last. Representative Seabaugh, if you want to come up. And we are working off a substitute. And I know you're going to address your underlying bill, and I'll let Senator Setzler address the substitute that he requested, working off of LC 560172S. I had not promised Senator Setzler if he took a flight somewhere, I'd do this on this bill, but that's what's working out for us, I think. So the floor is yours.
All right. Thank you, Mr. Chairman, Senators, for allowing me to present House Bill 1017, also referred to as the Squatter Reform Act. And I'm presenting substitute LC 560172S. As many of you have heard, squatting has become a terrible problem in Georgia, and this bill amends the official code of Georgia so that the rightful and lawful owners of a property can expeditiously remove an intruder, also known as a squatter, from their property. In this substitute, we added some of Senator Setzler's language from Senate Bill 470, specifically regarding a notice of vacancy affidavit that can be filed with the magistrate court when a property owner notifies the court that the land or tenement will be vacant until a certain date described in a signed affidavit. That's in Section 8, lines 129 through 171. So in summary, if your home is going to be vacant for renovations or goes on the market for sale, or you're just letting it sit vacant for any reason, this language affords another level of protection from squatters and allows law enforcement to immediately remove them from the premises. So why is this bill needed? This bill is needed because for property owners in Georgia, squatters occupying their property presents a very difficult and expensive legal problem as the law currently stands. We have homeowners tied up in the courts for 8 months to 2 years in some cases, trying to get these squatters removed from their property. Cases are backing up in Superior Court, and the local sheriffs are backed up in issuing writs of possession. We have real estate agents trying to show homes that they can't get into because squatters have occupied the home. And the worst thing is we have military members leaving for duty and coming home to find people squatting in their house. So Georgia property owners are suffering financially, and some to the point of bankruptcy. Senators, House Bill 1017 sends a message to squatters in Georgia, and that message is, you are criminals and you will be treated like criminals. If you commit the crime of squatting, you will be arrested, charged with a crime, prosecuted, and promptly removed from the property. You will be fined, you will pay for damages you cause, and you will spend time in jail. And if you want to play games by submitting a fraudulent lease or rental agreement, you may be charged with a felony and sent to jail on separate charges. House Bill 1017 sends the message there are no more free homes available in Georgia. And Mr. Chairman, this bill's been discussed in great detail, reviewed, debated, and revised. It unanimously passed the House Judiciary and the General Assembly. And I can go through the bill section by section and give specifics if you like, but your Senate analysis sheet does a great job of that, and I think given the late hour, it might be best if I stop here and just try to answer questions you may have.
All right, any questions from the committee to the author of the bill? Chairman Cowser.
Thank you, Mr. Chairman. I'm just curious, what's the law now? I mean, what do you do now without your bill if you come home from vacation, somebody's living in your house? What are your remedies?
So they're considered a tenant, and you have to go through the eviction process. So you file a writ of possession to the court, and that's taken 8 months to 2 years to get that settled right now.
Why not just call the cops and say, hey, a trespasser's in my house?
Because they won't do anything if they present a lease. They say, I have a right to be here, and the cop won't make that decision. They'll say, well, here's your court date. You need to go to court. I don't know how we got here with that. I had a constituent that called me, but he had a squatter in his house, and when we started looking at this, it's kind of taken a path of its own. I had no idea. Georgia's been rated the #1 squatter state in the nation. Not a number one rating that we really want. So this bill goes a long way in really getting the people out of the house in the most expeditious manner.
Thank you.
Thank you for the question.
Your questions from the committee for the author. Other people have signed up to speak. Mr. Olens, did you want to be heard as well?
I'd rather potentially respond if there's questions, Chairman.
Okay. All right, no other questions at this time. I'm going to go ahead and have Senator Setzler present his part of this, then the substitute, then we'll have testimony, because some of the testimony relates to the amendment. Senator Setzler.
Yes, Mr. Chairman. I think Representative Seabaugh nailed it. I think he covered it very well. The thinking is his bill creates this response to squatters. What the section of the bill that we passed out of Senate Public Safety, which is Section 8 and beyond, just gives you a proactive means. If you know your unit's going to be vacant, you can file this notice of vacancy. It's going to be with magistrate court. Pay $10 fee, and that registers it as a vacant unit, so that if someone is subsequently found in it, having proactively filed that notice that no one can lawfully be in this unit, law enforcement can then immediately remove them, and it creates a structure for that. The law enforcement is able to act pursuant to an order, as it were. So if you take the precaution to put this in place, they can remove them immediately, and they've got a 7-day shot clock to get them out. And also, law enforcement's protected. Any damage getting into the unit, that the landlord pays. It clarifies that the law enforcement's not subject to that. So that was drawn at the advice of law enforcement.
Any questions for Senator Setzler? What was your bill number originally? This was a bill you filed.
Senate Bill 470.
470. Yeah. And what's the status of Senate Bill 470?
It passed out of committee. Passed out of committee late before crossover day, and I was working on other bills to get on the calendar on crossover day, and it was just not picked.
All right.
Chairman.
Yes, sir. Mr. Olens.
If I may just add, I apologize. On my copy on line 144, it says the sheriff, marshal, or other like officer, and is that on your copy too?
It is.
And I would suggest it should be the phrase that's on line 75. Which is the sheriff,
Constable,
deputy,
marshal.
constable, marshal, or other individual certified by post.
That would certainly be a friendly amendment. I think we were thinking this was generally going to be a sheriff's prerogative to do this. Our thinking was that you could create an intergovernmental agreement between a sheriff and a police agency if that was amenable to the sheriff and the agency. So we didn't want to prejudge that, but if there's no objections, I'm not adverse to that language. So there's consistency. One of the things you'll see, Mr. Chairman, is on line 141. It says Superior Court. I had a sub drawn up that did not get to the committee in time for this. It's supposed to say Magistrate Court. So I wanted it to be Magistrate Court consistent throughout the bill at the request of the author.
Well, you have the similar language dealing with who's going to enforce this on line 157 as well.
You're correct, Chairman, that would need to be revised consistent with line 75
Line 75.
also.
And you also have Superior Court on line 159. Should also be Magistrate Court, I'm assuming.
Yes, sir.
Yes, sir.
All right, well, we now have some public testimony. If you all want to step aside, let me call up those that's time to speak. We'll start with Betsy, is it Bradfield?
Yes, sir.
The Georgia Association of Realtors. Betsy, how are you?
I'm well. How are y'all?
Good.
Good afternoon, Chairman and committee. Thank you so much for having me today. My name is Betsy Bradfield. I am the Advocacy Director for the Georgia Association of Realtors. I would like to thank Representative Seabaugh for his tireless work on this and also point out that he made it through 3 different committee meetings of House Judiciary. So this bill, the underlying bill, was incredibly well vetted, and we support that underlying bill. So I'm here to speak in favor of that. Squatters trespassing on property has become a huge problem for our property owners in the state, but it's not exclusive to Metro Atlanta. I'm having some property managers say that they're having issues in Valdosta. So squatters are currently illegally taking over our properties, destroying them, and causing havoc in our neighborhoods. A lot of times it also occurs with other criminal enterprises in the area. We're seeing some stories of human trafficking, drug cartels, things like that that are coming in, and they're happening in squatter properties. These are properties that should be put out to rent in our critical housing market, but unfortunately the landlords can't even get their own properties back from the squatters. So this is a huge private property rights issue for us and one of our top priorities for this legislative session, but we believe that we can solve it today with House Bill 1017. The substitute that you have before you does add in Senate Bill 470, which did not pass the Senate overall. It did pass for public safety, but it was not vetted by this committee. It does create a vacant property registry, which we oppose all property registries as an association. We also fear what could happen if a local government records are hacked and stolen, which is potentially what just happened in Fulton County. This provision would create a list of those vacant properties that could be sold on the black market if you have criminals that got a hold of them, of that list. And further, if the landlord accidentally forgets to withdraw the writ, I don't think that the substitute language speaks to the writ expiring. I think you have to go and withdraw it. If you forget to withdraw the writ and you let someone move into the property, we have concerns with potential consequences of what could happen to those individuals who are in the property. So we support House Bill 1017 as it passed the House. Thank you.
Any questions for Ms. Bradfield? You have a question? Senator Hodges, who's got their light? Senator Setzler.
Yeah, appreciate that, Mr. Chairman. I want to direct your attention to lines 172 through 179 of the bill. And there's also another reference earlier in the bill that specifically says, speaks to this issue of not having a property record, a registry. Because the public interest in this is not to create a magnet for squatters, saying that these are units that are vacant
Right.
that you can come squat in. We exempt this list from being subject to open records.
Right.
Now, if we're going to take the tack that if a system is hacked, then the hacker could get this list. I mean, that's not something we normally, as a body, think about. That because you've got this information that's being maintained by the magistrate court as a court record. Mm-hmm. If it's hacked, therefore we're vulnerable, therefore it's bad. That's not something we normally act on. That's certainly not that's not a. I mean, to characterize this as a vacant property record, when it's specifically exempted from public disclosure and an open records filing. How could that be a property registration?
So we support the fact that it is closed off to open records, and we really think that if this moves forward in this substitute, that line is really critical, and we appreciate you putting in that line to make sure that only certain individuals who work in law enforcement subpoena can actually get access to those records to carry out the reason for the bill, which is to get the squatters out of the property. So as an association, we have always opposed property registries. And so coming down here, it is, my responsibility to advocate against property registries. Rental registries are currently illegal under state law, and we hope to keep it that way. And this would just provide another mechanism, another sort of backdoor into rental registries. I love my friends in local government, but we deal a lot with dealing with local governments passing ordinances that create rental registries or property registries or list, and we have to fight those on a one-on-one, on a case-by-case basis. So we just have to oppose this part of it being in this bill.
Before this presentation, how many times have we discussed this?
Discussed which one?
How many times has the association discussed this opposition to this? It certainly wasn't presented in Senate committee.
No, sir, I do not believe. I was not aware that this was going to be added on until about an hour ago.
But isn't it true that when 470 passed Senate Public Safety Committee, it was not characterized as a rental registry, and that we put in this public disclosure, this open records component specifically at the request of the association, that we wouldn't create that?
I wasn't aware that it was specifically at the request of the association. We also opposed the version that was in the House that was before House Judiciary.
Yeah, so I just, Mr. President, or Mr. Chairman, I just wanted to, it's a surprise to me that this has been characterized as a registry. It wasn't characterized that way in public safety, and I'm certainly, because of that concern, it's why we made it not subject to open records, which I think is appropriate. But again, it's a question for every member to decide for themselves.
All right. No other questions in the committee. Thank you.
Thank you, everyone.
Next, we have Robert Smith with Prosecuting Attorney's Council.
Hey, good afternoon, Robert Smith, PAC. Just two quick things, and this bill was very thoroughly vetted for many, many hours in House Judiciary. Not the non-civil group, the civil group. So there's been lots of discussions. Just one thing I just want to advise you of: you are making a new misdemeanor crime in this, which would then be tried underneath this bill in the magistrate court of the county, unless they request a jury trial. And then if they request a jury trial, it would default over into either the state court or the Superior Court. So that's one thing that was kind of a bit of contention in the House side. But just want to make sure you know that. And the other one, to the Senator's amendment that was just mentioned, I know there was some discussion about open records. If you file something with the clerk's office, it needs to be under seal to make sure that it's not subject to the public inspection. Usually we don't file open records requests to the clerks. We just ask them for their court documents that are filed with the clerk. And if a document's with the clerk, it's open to public inspection unless it's under seal. So perhaps that might accomplish your goal a little bit easier. And that's all I got.
All right. Any questions for Mr. Smith? Thank you.
Thank you.
Next, we have Kristen Verrill with the Veterans Law Project Legal Aid. Good afternoon.
Did say it right.
Did I say it right?
Hi, my name is Kristen Verrill. I'm the managing attorney with the Veterans Law Project at Atlanta Legal Aid. And I am opposing the amendment that includes Section 8. The Veterans Law Project represents low-income veterans who are both tenants. We have had clients who've been victims of squatters. We've had clients who've been victims of rental scams where they believe they're paying rent through an online portal to somebody who does not own or have the lawful right to manage the property. And we have longtime tenant clients who have verbal leases, who have no documentation except proof of their rental payments that they are lawful tenants. And HP 1017, as passed by the House Judiciary Committee, took into account our concerns that actual victims of scams were not protected by the original bill, that month-to-month oral lease tenants were not protected by the bill. And it sets forth very clear processes for how a homeowner can deal with a squatter by calling law enforcement and having a very clear, concise process for how it would turn into a potential crime, into a civil process where everybody knows exactly what's happening. And this Section 8 muddies up the waters. It completely confuses what people should expect under various circumstances. I, as a lawyer advising a low-income veteran who is either a homeowner, a lawful tenant with a squatter, I don't know what to tell them what to expect with Section 8 included in this bill. And that's very highly problematic, because I think what's going to happen is we're going to end up with inconsistent activities based on local law enforcement's interpretation of this statute. I would suggest that we pass that you not consider Section 8 at all. The notion of filing a notice like you would file a notice if you go out of town with the post office is a good idea, but the way it is written is highly problematic. This notice does not require proof of ownership before you file this affidavit. It does not, if it's under seal, there is no way for a prospective tenant to have any notice that the actual owner of the property expects the property to be vacant. So victims of scams are going to be moving into properties and they will not have any idea that this affidavit has been filed. And there's no way for them to find out about it if it's under seal or not subject to public disclosure. There's no way for them to find out about it. The people who might find out about it will be cybersecurity hackers. And so it also provides no way for an actual victim of a scam to provide documentation to counter that, oh, I'm here because I've paid rent to somebody. And then they should be entitled to a civil process, an expedited civil process where they can have a hearing in court where a magistrate judge makes a decision about who has the right to the property, and it's done quickly, and then it's acted upon quickly. I'm not suggesting that we protect actual squatters, criminals in this situation. I'm saying that this amendment is very confusing and it doesn't protect all the people who are entitled to protection in this situation.
All right, you have a question, Senator Setzler?
And Mr. Chairman, I will, appropriate time, make an amendment, motion for an amendment to remove lines 128 through 179 from the bill. But I will say this, I'm going to make a broad statement. None of the remarks that I've heard in the last 10 minutes have been brought to me. I'm a detailed person. I don't glaze through details. I go way deep on detailed things. I've heard none of this. So it's just going to say parenthetically, this wasn't brought to us in public safety, wasn't brought to us in our Senate process, and I just wanted to make an exhortation of those who are part of this process that we invest time in these kinds of things. This is a real issue. The things that are caught in Section 8 and Section 9 are addressing a real problem and are incentivizing folks to take responsible action. I will not consider this terminated for this session simply with respect to the bill. The rep from the 34th, dear friend of mine, I'm going to remove it from his bill, but I would be lying if I didn't express great frustration at hearing about all this now.
All right, what we could do, thank you. Any other questions? All right, thank you.
Thank you.
No one else to speak on the bill. We could have the LC number prepared. We could do a motion to pass as pass the House version of this, which would be probably cleaner than amending this again with another LC. And so that would be the appropriate motion that could be made at this time. Let me get Senator Parent has the Ellsler. Let's see.
Thank you, Mr. Chairman. I'll move to pass on LC number 48124-2S.
And a second from Senator Setzler. And this will go back to the underlying House bill, which again, as you heard, would include everything except Section 8 and Section 9 in this bill. All right. We have a motion to pass, and it's seconded. All those in favor of the motion, please raise your hand. It is unanimous. And who is going to be carrying your bill in the Senate? Senator Setzler. All right. So we'll see. Thank you. All right. Next, we're going to go to, and give us 1 second to get in our folders, House Bill 1201, Representative Gaines. If you'll give us just a second, because I am jumping all around. We are working off of LC 520534S. All right, the floor is yours.
Thank you, Mr. Chairman. I'll be brief. Sections 2 and 3 were the version of this bill that passed the House, so I'll start there and then go back to sections 1 and 4. Sections 2 and 3 just ensure that victims of human trafficking that are sentenced under Georgia's First Offender Act or conditional discharge that are due to sentences that occurred as a result of their being trafficked have the same opportunity as victims who were sentenced otherwise. Unfortunately, those victims who were sentenced under First Offender Act or conditional discharge were left off when we passed the Survivors First Act, so that's just some cleanup language.
And I'll stop you. That we actually, this committee heard as a bill that Senator Estevez had, I think it was right before crossover day, that had that exact language in there. If it sounds familiar to you all, and it's exactly the same as what we passed out right before crossover day as well.
So that passed the House unanimously. That's sections 2 and 3 through the Criminal Justice Coordinating Council. Sections 1 and 4 is new to the bill, and that is on behalf of the Department of Human Services. Regina Quick is here, and she may need to come up if there are any questions on this, but it defines in Georgia Code commercial sexual exploitation recovery centers. As many of you have probably seen in the news, the First Lady unveiled Grace's Place that is going to support 24 child survivors of sex trafficking. Just an amazing work from Georgia's First Lady. Obviously, she's led on this issue for years, and Grace's Place is another iteration of that leadership. But this defines in Georgia's code recovery centers similar to that, which will help with licensing and otherwise. So that's really what sections 1 and 4 seek to do. And that's the bill.
All right, you want to add anything, Mr. Neal?
Mr. Chairman, I think the representative did a very good job explaining concisely what the bill does.
All right. Any questions from the committee, including a request to hear from Ms. Quick, if available? All right. There's one person signed up to speak on the bill, Robert Smith, again with Prosecuting Attorney's Council. He waives. All right. What's the pleasure of the committee? Motion do pass by committee substitute from Senator Watson, and a second from Senator Hodges. All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying this one in the Senate? Am I carrying it?
I was told you were,
okay.
but I don't know.
I will. All right.
Or whoever you appoint.
All right.
Thank you, Mr.
I'll
Thank you, Mr.
take this
Chairman.
one. Thank you. All right, let's go back now on the agenda. I think I made everybody happy. House Bill 909 at the top. Representative Hagan. We are working off of LC 481277S. And the floor is yours.
Thank you, Mr. Chairman, members of the committee. I have with me here Mr. Wade Askew from the Georgia Justice Project, who will be helping me answer any of your questions if need be. House Bill 909 would modernize Georgia's First Offender Act so that an isolated mistake would not lead to a lifetime of barriers. I was very excited to carry this bill when Mr. Askew brought it to me because I know people make mistakes. And this First Offender Act, when it was first enacted in 1968, gave people an opportunity to get their lives together and move forward without having a charge hanging over their head. However, we know technology has changed a great deal since 1968, and so in some ways, the First Offender Act is not as effective as it once was or as it could be. We know that everything is able to be found online. And so when a person, for example, applies for a job and a private background check company is hired, they don't just check GCIC oftentimes. They also check what they can find online. And so when these court documents are unsealed now, we have found that First Offender Act pleading first offender is not always an effective tool anymore. So this bill would remove that barrier of the criminal record that prevents many people from getting a job, renting an apartment, or doing the other things that people need to do to be successful in their lives and to support their families. And I know the Senate and the House this past year have been working very hard on looking at different workforce issues, how we can address workforce challenges that we have, the shortages that we have, and also both chambers have been looking at licensing issues to see what we can do to improve the system, improve licensing, so that we can get people working and fill these positions that we so desperately need to fill in our state. So this bill is relevant and timely to help us do that. So what does it do? It requires records to be restricted and sealed for first offender sentences at sentencing instead of at completion, so that during the time that a person is fulfilling their first offender sentence, they would be able to get that job, rent that apartment, do those things that they're trying to do, and that we would hope that they would be able to do. I would add that law enforcement and certain other agencies would retain access to these records should they need that access or information during the sentence period. I'd also like to point out that this bill does not change who is eligible for a first offender sentence, but it does change the timing of the sealing of records so that the original intent of the First Offender Act would be restored. And we do know from GCIC data that only about 2% of people who use the First Offender Act are not successful in completing their sentence. So this could positively impact many people who otherwise might not be able to enter the workforce because of their criminal record or because of licensing issues. So, Mr. Chairman, committee, that's the bill, and I'd be happy to take your questions or refer them to Mr. Askew.
You want to go ahead, Mr. Askew, as well?
Sure. Thank you, Mr. Chairman and members of the committee. So my name is Wade Askew. I'm the policy director at Georgia Justice Project. We are a nonprofit located here in Atlanta. We serve individuals across the state who typically contact us because they have some kind of old arrest, conviction, or first offender record that is now posing a barrier to them moving forward in employment, housing goals, or whatever it may be. And so I can walk through kind of very quickly what we are seeing right now that is really the cause for concern, the cause for the need for this bill, and then address just a couple of questions that have popped up, and then obviously I'm happy for any additional questions. So Representative Hagan outlined the issue very, very well. So I'll kind of walk through right now what happens if I am sentenced to a First Offender Act plea, or take a First Offender Act plea, I should say, and then where the gaps are. So let's say I was charged with misdemeanor or felony marijuana possession, a eligible First Offender Act offense. First of all, for me to get first offender in the first place, I have to be charged with an eligible offense. So we're not talking about the most serious, the most violent, or sexual types of offenses. It has to be statutorily eligible. This bill doesn't touch that question. Second thing is I have to have no prior felony convictions. So if I have already a history here, the First Offender Act is what it sounds like. It's for a first offense, that isolated young mistake. And then finally, I can't have used First Offender Act before. You get it once in your life. Now, if that happens, then I might pursue a First Offender Act plea. Prosecution, defense, judge work together in these situations to assess, is this appropriate for the First Offender Act? And if I decide to move forward with that, this is not a conviction, but I am very seriously volunteering myself to take a sentence to say, if I take this First Offender Act plea and I move forward and I make a mistake under that sentence, and that mistake, I should highlight, doesn't have to be a new criminal offense. It could be, Wade, you need to be taking a drug test every Friday. And if I miss a test or I fail a test, that could be reason to revoke my First Offender Act plea and be prosecuted to the full extent of the law on that underlying charge. So it is a very serious commitment. And as Representative Hagan said, we reached out to GCIC. In 98% of cases, folks make it through the First Offender Act plea successfully. So we are talking about overwhelming success with this. The issue is that people come to us and they have long since finished their First Offender Act plea. And they are told through this process, as long as you are successful, your case is going to remain private. It's not going to hold you back in employment. It is not a conviction, and it will be private. However, they come to us often a decade plus later and say, I just applied for a job. This case popped up. It cost me the job. What on earth happened? What can I do? And we have to explain to them that in Georgia law, we have a very unique way of handling our records where we restrict the official record that is held by the GBI and GCIC. But that only deals with the GCIC record. It does not deal with actual court records. We have a separate judicial order that handles keeping court records private to the public. Should not have anything to do with the court itself accessing its own records, or for prosecution, or for law enforcement accessing records, but the general public. We have a separate order there called sealing. What current law does is it says at discharge, the court must, there's not any discretion under current law, the court must restrict access to that record. But as Representative Hagan described, in our modern world, that is not adequate, because the way private background checks work is they access records from courts directly from national databases. And so that is why people are told one thing: this will remain private as long as you're successful, but that does not play out in reality. And so that is why the two must go together for the intent of this legislature, as expressed in 1968 and onwards, to really be effective on the ground in the real world for individuals. So and once people are in that position, again, the damage is very much already done when they come to our office. They were simply unaware that there was this hole until they've reached that issue. And we have to go through a labor-intensive process that spends a lot of court resources to then go through the sealing process. I mentioned that, as with all case records that are restricted and sealed, law enforcement, sensitive employers like elder care, child care, court personnel, they all retain access to sealed records. They can all see it. We worked with the GBI, with DCS, and with PAC each to make sure that both under current law, because records can be sealed under current law, this is already happening, to make sure that under current law, and especially if we pass 909, that is happening with ease, that is happening correctly. And so there are additional provisions in here to make sure that probation has access, to make sure that prosecutors have quick and easy access to records that they need to see, law enforcement, and so on. I do want to just address a couple quick things that I know have come up. One is we had a question around drug courts and accountability courts of, will this cause issues for those to be able to move forward? The answer is it should not, because if someone is serving a First Offender Act sentence and is regularly coming back to drug court, for example, the court, prosecution, defense attorneys, they all retain unfettered access to those records. So we're not going to need to seal and unseal. And also, if a record would only be unsealed if someone is actually revoked and a conviction is imposed, which is a once and for all thing. The second thing, there was a question about victims' restitution. If I'm a victim and I need to make sure that restitution is being paid, how will I be able to contact someone? Again, that should be solved by the fact probation, prosecutors, they can see the records. So if I'm a victim, I can reach out to probation, prosecution, and they can tell me. The last thing I just want to touch on is doing this at sentencing is in part just to preserve judicial economy so that at the time of sentencing, when an order is made, it is taken care of then and there. We're not hauling everybody back into court years later at the end of a sentence. And would just like to note that we have spoken with all the parties I mentioned, as well as the Superior Court Council of Judges who are not taking a position on the bill. And so our hope is that with this bill, we are solving a very real problem that a lot of people are facing, where kind of the promise they are given is not meeting reality, and that is the narrow issue that we are just trying to solve for. So thank you.
All right, questions from the committee. Senator Hodges.
Thank you, Mr. Chairman. Thank you, Representative, for bringing this bill. I've had some input from Superior Court judges today. One in particular I'm very familiar with, who says that, that he really believes in first offender status and what it does for our society. And he agrees with the premise of what you're trying to do, but this bill in particular, as it's written, has some impracticalities about it. And probably the best thing for me to do, just very quickly, is let me just read this, if I might, and then some of this you've commented on, but if you would, please. Mm-hmm. The bill requires a restriction and sealing of first offender sentence before they've completed their sentence. We, judges, have the discretion to do this now, but this bill takes away judges' discretion. While it sounds good on the surface, it has a lot of practical problems. Don't mind giving a person who is a first offender the benefit of that statute, but if I have that person in drug court, which I believe you discussed, then I cannot be sealing and unsealing the record every other week in drug court or other accountability courts. Also, if you happen to be a victim of a theft and you want to know if the perpetrators paid ordered restitution to the clerk, you can't find out if they're, how they're doing on probation, if you want to know. And this is one of the big things. Many of the computer systems, and he mentions there's something like, we have 159 counties and many different case management systems. You would know that better than me. But many of the computer systems, when you electronically restrict, that restricts for everyone, including judges. If the physical file is sealed, then that prevents problems for probation, revocations, accountability courts, etc. And this is the thing that bothers me. He says to me the effect of this bill will be for many judges to decide not to grant first offender, which would be most unfortunate. And then one other very quick aside. This bill seems to be one-sided. It only protects and looks after the guy who committed a felony, who's looking after victims or the public's right to know and what goes on in the judicial system in the courtroom. Why is there this overwhelming desire to help the criminal before he or she's demonstrated any hint of contrition or completed some steps toward making himself or herself, his victim or society any better? So comment on that, if you would, please.
Yes. Thank you, Senator Hodges. And, first and foremost, I absolutely appreciate and applaud the sentiment of the First Offender Act being very important, and the last thing we would want to do would be to put any chilling effect on it. You will not find an office who would want that less than ours. So I'll try to take those. I wrote those down as you were speaking to try to take them one by one, but I'm happy if folks want to jump in as I go. For the drug court issue, like I mentioned, I don't believe that should be a dynamic where things are being sealed, unsealed, because first, when a defendant is coming back, something like drug court, someone's coming back in regularly, all the parties in that courtroom have access to that record still. We're talking about public access, so access by employers, housing providers, et cetera, not court staff. So, and then in addition, judges would not be unsealing or unrestricted just based off of something de minimis that they don't think is rises to the level of a revocation. So if there is a situation where someone has violated, is being revoked, and a conviction imposed, that is where we unseal. But until then, it just remains sealed. There's no back and forth. But the important personnel can still see it, and we want to make that crystal clear in here. Again, not just for the future when we're living in a 909 world, but even for current law, because again, records can be sealed now. We want that to be crystal clear. The second, for the victim's restitution question, because of that access for probation, and again, we worked with DCS to make sure that again was crystal clear that they have this access. Someone is on a first offender sentence, they need to be able to see it. We agree with that. Probation, prosecutors, they have access. So if I need to reach out to the prosecutor who handled the case and say, have you been able to collect, or probation, have you been able to collect, I'm having issues, I'll still be able to do that, and they'll still be able to do something about that issue. On the computer system issues, what I would say is that it is absolutely true. We have a bunch of case management systems, a bunch of court systems throughout this state, and that is something that we run into all the time, absolutely. But that would be an implementation and computer system issue where they have the ability, frankly, they already should be programming those systems in a way that judges, prosecutors can access, law enforcement can access, because the law already is clear that judges should be able to see those. So we would be very happy to work in implementation with those CMS systems, with clerks, whomever it may be, to make sure that they understand what the law is, so that they need to program those in a way that every party that this law says needs to access these records can do so. The question on the chilling effects, like I said, I very much respect and appreciate that question. It's the last thing in the world we want to do. What I would believe is that the way that this is written, to make sure to, number one, ensure that if somebody makes a mistake and if somebody is revoked, it becomes public, that any judge who is going to give first offender in the first place, if they are concerned that could happen, that fail-safe is already there. To make sure that becomes public. And then secondly, there are all of these carve-outs trying to protect for victims' issues, probation, prosecutors, law enforcement. There's special provisions around there. If I go apply for a gun while I'm serving the First Offender Act, make sure that that's going to be caught, make sure that's not going to be an issue. And again, these are all issues that could pop up even under current law that we're trying to double back on to say, even under current law, we want to make sure that all these parties have access, and we are improving the situation. And then finally, just some thoughts on kind of victims' rights type of issues. Many of our clients themselves have been victims, and what we're talking about here with the First Offender Act, again, are not serious violence, serious sexual offenses. We are talking about kind of your isolated population where we've made an isolated mistake, and the data backs that up, where 98% of people are successful and move forward and want to be, tax-paying, contributing members of society who made a mistake, like we all do. And so the way that this is written to, again, try to protect for law enforcement, prosecution, courts, retaining access, making sure that we have provided all the supports and all the supervision needed here, so that an individual can move forward successfully, and at the end of the day, actually drive down recidivism rates, because we know that if somebody is able to get a job, their likelihood of getting arrested again is cut in half. And we also know that sealing access to records increases wages by an average of 22% within a year. So we're talking a significant gain on people. This is effective. It has been seen out, and that is good for public safety. People whose records are sealed statistically are highly successful. But we have it in here that if they are not, and that is good for public safety, but if they're not, everything becomes public again. So our belief would be that it would be something that is good for both victims and the folks who are under a First Offender Act sentence.
And Mr. Chairman, if I may just address that very, very briefly. As a non-attorney, I'll be much quicker than Mr. Askew was in that response, so you may appreciate that. First, as far as judicial discretion, we certainly do not want to impede that in any way. Judges currently have discretion on whether to even accept a first offender plea, and this bill would not impact that in any way. And then also, I think it's important to just mention that if someone violates their first offender sentence, the judge has full discretion at that point to, I don't know what the correct legal terminology is, but to draw back that sentence and unseal those records and sentence them as a judge feels accordingly. So I think it's not necessarily taking away judicial discretion. It's just making sure that we have restored the original intent of the First Offender Act, which then to the next point I think is very important, because when we're looking out for, I don't think we're looking out for felons here necessarily, because many charges, felonious charges, are not included. They're not eligible for first offender at all. But what I do think is important is to give people who have made a mistake, and haven't we all made mistakes in our lives, for them to have a second chance. And that was the original intent of this bill, this act in 1968. And given that we know that 98% of people who take a first offender plea and have their first offender sentence, they're successful. And when I was working on this bill, I spoke to law enforcement officers and sheriffs back home that I trust greatly for their opinion on matters like this. And they stressed that they want to help people in the community, and they want to lower that recidivism rate, and they want to see their constituents successful. And so I think that is what's at the heart of the First Offender Act originally, and that this bill just enables that, to give those people who have made a mistake of a certain nature the ability to recover from that and move on for their lives, with their lives, and to support their families, and to go on to do whatever they would be doing had they not made that mistake. So I'll leave it at that.
Senator Kennedy.
Thank you, Mr. Chairman. I was going to say good afternoon, but it's good evening now, isn't it? As well often happens. Representative Hagan, thank you for bringing this. I want to say that I support the First Offender Act, and I support its implementation. I think it does wonders in the lives of people, just as you described, those that make a mistake, and they ought not to have their life completely derailed because of that. So please understand, I'm with you on that. But I too, like Senator Hodges, received some communications from a judge about how this gets implemented, and if there wouldn't be some unintended consequences. And so that's the root of my concern. It's not questioning the act. It's not questioning what you're trying to do here as well. And I appreciate your responses. I think much of what you said in response to Senator Hodges' questions really were addressing the viability and the efficacy and the value of the act itself. And I don't think he can speak for himself, but I'm not questioning the act, and I don't think Senator Hodges is either. I don't think you're going to hear that from this committee. But I am concerned about some of the same things that were mentioned. What do you do? What does the judge do when they've got someone in drug court, as was mentioned, and it's restricted, but yet now you need contemporary access on a biweekly basis because they're in drug court, or you've got the restitution issue. It complicates things, and I don't practice in this area, and thankfully I've never availed myself of the First Offender Act either, so I don't know as much about this, certainly as the judges who deal with it on a regular basis. And so I just want to make sure that if we're going to tweak this in a way that I like the objective of it, that we do it in a way that doesn't complicate things for judges. And then, of course, the big uh-oh that we've got to avoid is, as has been acknowledged, is if this gets functionally implemented in a way that judges then dial back on their willingness to give it, now we've moved the needle in the wrong direction and the opposite in which both of you I know want to. And so, unfortunately for me, I didn't get the information until this afternoon, so it's not that I've had time to study up on it, if you will. So those are my concerns, not trying to derail the bill. I think the objective of it is good, but I know collectively we certainly want it to be implemented in a way that doesn't go backwards for some people that would very much want to have access to that. So, Mr. Chairman, that's I'm not going to ask a question because I think the questions I had really have been asked and answered, and from that standpoint, I would like to see us maybe at least take a little bit of time to address some of these, to collectively, just between now and the next hearing, that is, not beyond that, collectively make sure that these administrative issues that are being raised by people who live in this world every day, that they're addressed, and maybe some minor tweaking of the language might address all of that. I don't know.
All right. Any other questions from the committee? We have two other people want to be heard on the bill. First, Robert Smith again, Prosecuting Attorney's Counsel. You're busy this evening. It is.
Good evening, and I might actually be able to answer a question or two. We appreciate the partnership that we have struck up with Georgia Justice Project over the years. It's a partnership that we formed with the Deal Commission on Criminal Justice Reform, some of the bills which you, Chairman, were a sponsor of, if I remember correctly. And this is something, the First Offender Act is something that's a very valuable tool. I used it when I was a line prosecutor. It was something, it is a wonderful thing because you're dealing with somebody who has never had a felony conviction before. And one of the things, Senator Hodges, you asked about, it can be applied to misdemeanors as well. Wouldn't suggest it. I've never been on the other side of the table. I've always been on the state side of the V, either defending the executive branch or prosecuting. But as a criminal defense attorney, if somebody came up and said, "Hey, I want to use my first offender," my client wants to use his first offender or her first offender on a misdemeanor, you sure you want to do this? But it's available if they want to do that. Right now, and one of the interesting things, Senator Kennedy, one of your elected prosecutors, and Senator Parent, one of your elected prosecutors, need this bill. Because there's a disconnect. There's a concern with the clerks sharing information. Basically, when you've got a case that has been sealed, even though the statute appears to be clear that we have access to it, we've got elected prosecutors who cannot gain that information. We have other ways of getting around it. You figure out on a criminal history where the person got prosecuted, and you go to the DA or the solicitor and get their file, and that way you then know how to ask. But when we're trying to make sure somebody is a candidate for a program, or if we need to allege possession of a firearm by a first offender, those kinds of information, we need access to this. And that's one of the things I want to thank the sponsor and Georgia Justice Project, because I asked to have the clarifying language in this bill to make, which is part of the committee substitute, to make sure that my prosecutors can get the information we need. How does that carry over? Well, that carries over not just when we're trying to figure out how to prosecute somebody a second time or prosecute somebody a first time. It also allows us, because we are a partner in the accountability courts programs, we are the gatekeeper. So when you have the treatment team, when you have the judge who is sitting over the veterans court, the family responsibility court, the mental health court, the drug court, the DUI court, I can keep going, but all of the accountability courts, you have a treatment team, and that treatment team may differ from court to court, but the constant throughout is the prosecutor. And and this gives us that information. So if somebody's trying to come into a treatment program and there's a question about their criminal history, by this bill, we would still have access to that information and be able to provide that to the court and be able to get that information. What we're talking about and what this bill is intent to do is the very definition of what the First Offender Act says it is. It is not a conviction. So you're trying to make sure that and this is a goal that an aspiration that was started several years ago by this body and the other chamber, that someone who has not been found guilty is in fact recognized as not being found guilty. They're not, yes, you're a first offender, and there are some, limitations on what you can and can't do, but you don't have a conviction. And therefore you are able, when you apply for a job, you should be able to say, I'm not a convicted felon. Don't check the box. So you can get advance on the job. When you apply for housing, hi, I don't have a felony conviction, I'd like to be seen. When you apply for benefits, all of those things that help support someone who is on probation for a First Offender Act, so they can be successful rather than being part of that small percentage of people. And on a practical basis, let me tell you, one of the hardest things to do is after you have negotiated a guilty plea and the judge withheld the adjudication of guilt because the person could get sentenced under a First Offender Act. When you get that report from probation that, hey, the person you put on first offender probation, they messed up. Well, what did they do? They missed curfew. They're too much past due on their fines. Because as a prosecutor, that puts us in a very awkward position. Because yes, I can, and I hate to do that gesture, I apologize, but just, hey, if I want to, I could, ask for a violation of probation. Put them back in front of the sentencing judge, then basically say, hey, judge, sentence range is 1 to 20 years in prison. You can sentence them all the way up to 20 years in prison right now. Originally, you gave them 3 years probation as a first offender, but now you can give them the max if you want to. Not the fair thing, and that's up to the judge, completely up to the judge on their discretion on how to resentence. But it puts us, I know it's a dirty word, but it puts us with our discretion as to when is the appropriate time to seek to have a revocation. And we have to then present evidence. And there are times when I have sought to have a revocation of a first offender, and the judge would look at me and go, Mr. Smith, yes, you've proven your case, but I'm not going to revoke today. I'm going to give the first offender another chance. So understand, there's not just me with my discretion, there's also a judicial discretion as well to make sure this person gets this huge benefit. So 909 clears up some things, and it helps us be able to make sure we can get access to records that we need. But I want to make sure you also understand from somebody who's been in the trenches and who's used first offender and seen how first offender works, what it does, and what the state is right now for us.
All right, any questions from the committee for Mr. Smith? Senator Calzert?
I don't know if I followed you. You support this bill or not? I'm being dead serious. So you think this is a improvement or something that you'd rather not interfere?
It's something that helps. There's a provision here that helps prosecutors, and it's a continuation of legislation and aspirations that have been started years before.
You support it? Okay.
I'm trying to. So me supporting, and basically, I can tell you that there's no DAs that are against this. There's no solicitors that are against this.
Okay.
How's that for an answer?
That's good enough.
Any other questions from the committee? All right. Senator Hodges.
Can you speak to the impracticalities that were discussed earlier at all? The system impracticalities.
In terms of like why a judge might decide not to?
No,
okay.
no, about difference in systems and how what is sealed for some people might not be restricted or sealed for other people.
I don't want to wander too far out of my lane. The clerks work really hard. The clerks have lots of data. I believe it was 2 years ago that y'all passed a bill 407, I think, the CDX, and the requirement that we get criminal data done quickly, criminal disposals done quickly. So there is a lot of people working hard to get that information out as quickly as possible, but computer systems are just as good as the information you put into it. And if you want a perfect system, I can't guarantee you that we have one. I can tell you that everyone who's part of the criminal justice system is working hard, especially after being told by this body to do so, to make getting us as close as we can to it.
Any other questions from the committee? All right, thank you.
Thank you.
Next, we have James Woodall, Southern Center for Human Rights.
Thank
See you
Mr.
again.
Chairman. Nice to see you as well, and I'll be very brief. We at the Southern Center for Human Rights are very supportive of this measure, and I'll also go further to add that to the questions that Senator Hodges has raised. Senator Kennedy has been working diligently over the past several years to improve some of the court systems that we have here in communication between the clerks and the superior courts. That's an ongoing process. But as far as this legislation goes, this is, we believe, good legislation, and we hope that this committee favorably considers it and moves it out. Thank you.
Thank you. Any questions for Mr. Woodall? All right, thank you. That's everyone that signed up to speak on the bill. At the request of members of the committee, we will hold on taking a vote on this evening, but the bill will be available in future hearings. If you can work with those that have expressed some concerns, just help answer questions and see if we can get to a point where people are comfortable with the bill. We hopefully can get it out sooner than later. We have a hearing tomorrow, but it's at 11 a.m., a little bit different for us. It's probably more practical to look at this again maybe for Thursday at our regular time, or potentially a week from now at a regular time. So thank you. Appreciate it. All right, next on the agenda, House Bill 910. Chairman Jaspers. Is this your first time in front of this committee? All your time around here?
Yes, sir.
Yeah. We were working.
And the other night when I came home from a dinner, I met one of your members in the parking lot. I said, "Oh, what dinner did you go to?"
Yep.
And you know, but yeah. Oh, thank you for letting me be here.
Yeah. Well, some people like to try to bring us dinner when we're here, but I see you didn't bring anything. But
Yeah. Well,
we're working off of LC 481267S.
Yes.
And the
That's
floor is yours.
Well, thank you. When I started this little journey with this bill, it came from a friend of mine that lives up above me in Bent Tree, Jeff Anderson, and he's one of these guys that kind of sends me information every day about what's going on, because we're down here, it's hard to know. And he goes, "Rick, I saw this back early January in Louisiana. You ought to take a look at this." And I said, well, so I just kind of put it in my file, and I gave it to my intern, Jackson Cleette. And I said, "Hey, look at this. What's this bill do? What do you think is this? Should we spend any time on it? Because, we're all busy folks." And this is a pretty simple bill. It's had a great court ruling this past week to make online porn retreat. And I'm probably not the guy that you would think would be carrying a bill like this, but it just struck me, wow, what a simple idea, that all we have to do is ask somebody to show their ID online on a porn site to access it, just like we do in a store. When they go to buy a pornographic magazine, they have to show an ID. Buy vape, do many things. We show this. This is what this bill does. Does it pretty easily. It's been acted on in about 9 states. There's about 20, according to Jackson, that are engaged in this right now. It's been in court. It's been upheld, and it's pretty neat that we can be in the position to do this. But what this does, really, it requires to access a porn site. Of course, you're 18 years old, and the porn site has to have 33.3% of pornographic material. For you to get on this site, you got to show a government-issued ID, like a driver's license, whatever. We have electronic driver's license now. 300,000 Georgians have taken advantage of that. Companies that violate it, can be sued in a local court by the parents of those minors who are able to access the site without being verified. This ensures compliance. Now, I'm not going to go into all about what pornography is, but we'll tell you it's bad for young people. It promotes negative attitudes toward women and violence, sex trafficking. It promotes that. I've had teachers, my own daughter, who's a high school teacher, Jackson's mom, who's a high school teacher, constantly are taking phones away from gentlemen and women, believe it or not, who are watching porn during class. And it's an addiction issue. You know, I've been asked many times about user privacy. When you read through the bill, we'll be glad to answer any questions about it. Wonder if it will lead to sensitive data collection. Well, the first thing I said, you don't have to get on a porn site, and then you don't have to worry about it. But it does require that they've got to they have to delete the data that someone would provide them upon verification. And the law only requires you to show that, like I said, that's already out there. They have to do it for vaping, adult bookstores. It goes on and on. And so what happens? What's happened in other states that have passed this bill is the porn companies have withdrawn from the state due to the liability of the court of being sued. Now, they've been to court a little bit. They were in Texas, and got a neat little judgment from Texas just this past week. It was on Friday. I was listening to NPR this morning. Please don't judge me. And I heard this, so Jackson looked it up for me. And the 5th U.S. Circuit Court of Appeals in New Orleans upheld Texas's law, which is almost identical to the law that I have before you today. And so it's amazing. It's pretty easy. It's something that's worked in other states. Did bring a sub in the House committee that chose to remove, what you'll see on line 84 through 87, some protections for online providers of new public news broadcast, news gathering organizations, cloud service providers. When they took that out, 2 days later, there was quite a line of people at my door to talk to me about getting this back in there, because this is one of those things that does protect that group of people. Even though they are protected under federal law, they really wanted to see this in here. And Jackson really took time and looked at all the other states that have similar laws or laws like this in the way they all have those 3 or 4 lines in there. And I smile when I say this bill. It's amazing that something this simple could really change what our young people see. And does it protect children? Yes, absolutely. It protects children. And does it violate anybody's First Amendment's right? No, it does not, because that stuff's still out there. You just have to prove your age. I think it's a win-win for everybody. I have not yet seen any negatives. I think as we've really critically looked at it, as I had him do, I'm a pretty careful person with bills, and I appreciate my intern's work on this. He had to go home for a different thing for his parents tonight. But, Mr. Chairman, that's my bill. Didn't go through it line by line. Be glad to answer any questions, or if you'd like for me to, I can do that also.
All right, do we have any questions at this time from the committee for the author? Are there others that want to be heard on the bill? All right, thank you. We'll go ahead and do public testimony.
Okay, thank you, Mr. Chairman.
We'll start with Karen Dial from Flowery Branch.
Thank you. My name is Karen Dial, and I am from Flowery Branch, and I would like to thank Chairman Brian Strickland and the other members of the committee for hearing my testimony today. I will speak in support of age verification for pornographic websites. The next few minutes are really, really important to me. I'm a mom, a grandmother, and a high school teacher. But today, I see myself as defending Georgia's kids against a multi-billion-dollar industry that has sexually harmed children. I first learned of childhood addiction to pornography when one of my students told me and the entire class that he had been addicted to internet pornography from the age of 7 until the age of 9. I was shocked, but what exactly was he addicted to? My idea of pornography was the photograph of a nude woman. Not long after this, a family friend found rape porn on her boyfriend's phone. Rape porn, was that even legal? Or was that hard to obtain? So I started my research. I got an education in the violent reality of internet porn, the widespread viewing by children, and the horrific effects on a child's behavior. First, hardcore violent pornography is now mainstream pornography. What will a child see? One researcher found that 88% of popular videos contain violent gagging, choking, and slapping during the sex act. The woman's body is penetrated and pounded in her vagina, anus, and mouth, sometimes by more than one penis or even a fist. In the end, the man often ejaculates on her face. This, I'm afraid, is mainstream pornography. And the storylines? Let me describe 3 of the top genres. Rape porn. A violent rape is acted out, and the woman smiles like she liked it in the end. Incest porn. Sisters and daughters become the rape victims. And teen porn. Young women who look like little teen girls are put in horrifying sexual scenes, and this is the most popular genre of porn on the internet, yielding over 3 billion results. So, how many kids are being instructed by hardcore pornography? The average age that a child sees porn is 10, and many, like my student, are much younger. Let's imagine the reality of a 7-year-old watching rape porn or even gang rape porn. That's just another click away. How many kids watch it? One researcher says that 90% of American teens have seen porn. This book is Raised on Porn, about childhood addiction, and it contains 15 pages of cited scientific sources. Finally, if the scope is this large, we should expect to see changes in the behavior of children. I have attended 3 conferences in Washington, D.C. of experts concerned with this crisis. What was one of the main topics? The significant rise in child-on-child sexual abuse seen by school teachers and hospital nurses. Many experts claim that children are attempting to act out violent pornography on other children. The National Center on Sexual Exploitation in D.C. has many of these testimonies on file. What if you passed this bill? A little boy like my student now faces a barrier that he cannot cross into a world of violent porn that he cannot control. He is finally protected. Thank you for hearing the difficult testimony. I can take any questions if you have them.
All right, any questions for Ms. Dial? Thank you. Next, we have Mac Parnell, Executive Director of Georgia Faith and Freedom Coalition. Good evening.
Hey, good evening, Mr. Chairman. Thank you so much for taking the time to hear this piece of legislation. Thank you, Chairman Jasper, for bringing this important piece of legislation. I'm actually sorry that this is something that we have to address. It's not something that you really want to think about or even consider, but it is an important act to protect our kids. We support this legislation. Thank you so much.
All right, thank you. Next, we have Mike Griffin, Georgia Baptist. Good evening.
Thank you, Mr. Chairman. I am Mike Griffin. I'm the Public Affairs Representative of Georgia Baptist Mission Board. And, you know, one of the 4 top priorities of Georgia Baptist in legislation has to do with child protection policies. And, of course, you know, children are one of the most vulnerable groups of people in our nation. We're living in a day when children are suffering the most from societal ills that they are now facing from our culture. In addition to working with the Public Affairs Department with Georgia Baptist, I also do child protection policy. And I have worked very closely with Greg Love, who is with Ministry Safe. I did about at least 7 classes last year on child sex abuse protection. And just what you just heard in some of this testimony before me, Greg sent me an email when I was in the middle of doing some of our Spark conferences, which had a breakout session for child abuse protection, that 52% of the sexual abuse that children are going through today from a call list of where they were being reported was up to 52%. So for the first time, we're seeing peer-to-peer abuse being greater than adult to child. And one of those reasons, I believe, is because of the early exposure to pornography. And I've seen that same data that children are being exposed anywhere from 9 to 10 years of age. And we passed a resolution dealing with this at Georgia Baptist Convention 2017 entitled "The Moral, Societal, and Public Health Crisis Created by Pornography." And so we are for your support of this legislation because we do believe that we should be as extensive as possible in making sure that we protect our children on the internet, social media, in any forum that we have out there, especially that dealing with technology. Now we need to be protecting our kids. So we appreciate your favorable support for this legislation.
All right.
Thank you.
Thank you, Mr. Griffin. And last up, Chelsea Thompson with Frontline Policy. Good evening.
Good evening, Chairman, members of the committee. My name is Chelsea Thompson. I am General Counsel of Frontline Policy. And I want to thank Chairman Jaspers for bringing this important legislation. I am here to share our support for HB 910 and to also advocate for the importance of this legislation that protects our children from accessing such material, as well as significant impact this could have on our Georgia adolescents and our society. So as a whole, harmful to minor laws generally seek to protect minors from pornography, obscenity, and other such material that may bring harm to them. With the rise of technology, as we've seen, lost my place here, sorry. Minors currently have nearly unlimited access to adult websites, many of which contain inappropriate and pornographic material. Studies have shown that by the age of 17, about 75% of adolescents have been exposed to pornography. This statistic is quite alarming and is made possible by the fact that many of these websites are accessible without parental permission through age verification. Most kids, just to kind of provide some context and statistics for this bill, most kids today are exposed to such material between the ages of 10 and 13, as you've heard in other testimony, with 84% of males and 57% of females ages 14 to 18 having viewed such material. 73% of teens reported that they have consumed pornography. And at least 1 in 3 pornographic videos, as you've heard today, show sexual violence or aggression. Porn titles shown to first-time users also on porn sites' homepages describe acts of sexual violence themselves. Over half of 11 to 16-year-old boys, 53%, and over a third of 11 to 16-year-old girls reported believing that pornography was actually a realistic depiction of sex, and which is horrifying, obviously, considering some of the testimony you've heard. 58% of teens had stumbled across pornography accidentally, which this bill's requirement of verification would substantially limit. And 71% of teens have done something to hide their online activity from their parents. And this bill helps put parents back in their rightful place of controlling whether and how their children engage with dangerous pornographic material online. And parental oversight is already required for a variety of things, so including liability waivers and contracts, and it should be necessary in decisions relating to children's exposure to pornography as well. And I really don't need to get into the details of why this matters and why it's important, but it has been shown that consumption of such material has been linked to loneliness and a lack of self-control, depression, stress, anxiety, and other mental issues, and also, as Chairman Jasper mentioned, diminished view of women's worth and competence, morality, and humanity, right? Experts have determined that 4 major brain changes common to addicted brains can all be found in cases of pornography consumption as well. And I would argue that these are the reasons, right? That this is why we need this bill, to protect our Georgia minors from such negative influence and mental, physical, and emotional harm. We already see and have protections and limitations in our Georgia code right now addressing this issue in regards to sale or distribution of content and material harmful to minors. And this bill only expands that intent to protect adolescents from such content by online providers that allow access of this material harmful to minors. 8 other states have passed this legislation related to pornography, porn age verification specifically, and there are 49 bills currently in progress this year across 20 states, 2 of which are in Congress, which some of you might be familiar with, the Screen Act and others. In 2022, the Louisiana bill that Chairman Jaspers mentioned passed. It was HB 142, and Pornhub implemented the system from the bill, and it saw the traffic from Louisiana, Pornhub's traffic went down by 80%. And now Utah, Virginia, North Carolina, Montana, Mississippi, Arkansas, Texas, and others have also passed similar legislation. And Pornhub has also since pulled out of all of those states. Some claim that this is where the government should stay out of matters relating to children's online access, and that decision ultimately belongs to the parents. And I've said it before, and I'll say it again, that we wholeheartedly affirm that, and we affirm that decisions pertaining to a child's time online does belong to the parents. And this is why we strongly urge you to support this bill, and the age verification requirements will place these decisions and others back into the hands of parents across Georgia. So we do ask that you do pass on this bill. Thank you.
All right, thank you, Ms. Thompson. All right, that's everyone that's signed up to speak on the bill. What's the pleasure of the committee? Motion do pass by committee substitute from Senator Watson. We have a second. Second from Senator Kennedy. All those in favor of the motion, please raise your hand. It is unanimous. And who's going to carry it in the Senate?
Senator
Anavitarte. All right. Thank you.
Thank you. Thank you, committee. All
right, we're in danger of losing a quorum, which we actually have lost a quorum. No pressure. So Senator Jones comes back. We will. We have 3 bills that should be kind of quick. Only one person stopped to speak. We need all 3 bills in there for it. Yeah, just get Ben to. We have a quorum again. So, Senator Kennedy, real quick, will you present for us House Bill 992 for Chairman Blackman? I believe this is just adding a new judgeship to the Houston Judicial Circuit.
Mr. Chairman, that's exactly right. That's all it does. I'm going to try to be uber efficient. As we all know, there's a process by which judges or judicial circuits can add a judge to their circuit. They are ranked based on the amount of workload, and typically every year the legislature will add a judge to one judge to 3 circuits. I think that's being proposed. That's being done this year as well. And Houston County is the second most overworked, if you will, or has the second highest workload of judge to case and the metrics that they use. And so this is, they are in line for that. And I would ask that that we pass this out and allow Houston to go to add a what will be a 4th judge. They'll go from 3 to 4.
And we are on LC 481078. What's the pleasure of the committee?
Pass.
Motion do pass. Is there a second? Second. All those in favor of the motion, please raise your hand. Are you carrying that bill for him in the Senate?
I think I am, Mr. Chairman.
Okay.
Yes, sir.
All right. Thank you. And House Bill 934. Representative Montahan, come on up. We are working, if I can find it, off of LC 481202S. This is as passed the House, I believe. Is that right?
That is correct.
All right.
Mr. Chairman.
Well, you try to keep us with a quorum. We might move your bill.
Yeah, we're gonna try to move it pretty quick. Like Ricky Bobby said, like to go fast. So I've got HB 934, and I'll kind of give y'all the highlights for sake of time. Basically, this allows self-storage owners and operators to use electronic agreements. That has not been changed in state law since the last time we visited the self-storage laws are on the books today. So this does allow them to have these electronic agreements. It allows them to renew these in a kind of a post-COVID world where everything's online and everything's digital, and that's Number 3, also, it also allows them to terminate a customer for a reason that isn't non-payment. So I'll give y'all some examples. We have one where a customer placed crates of used cooking oil in the property. Obviously, it became rank. It took months and months and months through an eviction process to get rid of that, and they had to remove those flies and everything else that you can imagine. There was another case where there was cartons of onions that were not tended to, and they rotted in the self-storage unit. And there was another case where they actually had created a methamphetamines lab in the self-storage unit, but they could not get rid of the material nor clean that unit for months and months because I had to go through this lien process. That is the bill. I do have someone who can give testimony. For sake of time, if y'all would rather him just answer questions, I am not a lawyer. He is Emory trained, Atlanta native, so maybe that's better.
All right, let's see if the committee has any questions. No, we do not have any questions. We may have a motion. What's the pleasure of the committee? Motion to pass from Senator Jones. Is there a second? Second from Senator Kennedy. All those in favor of the motion, please raise your hand. All right, it's unanimous. Who's carrying it for you?
I was going to ask and see if, let's see, I guess Senator Anna Battardi, if he's my senator, and I think
see if
he'd
he
like
can
that.
carry it for you.
Thank you very much.
All right, thank you. All right, next we have House Bill 1054. That'll be the last one on our agenda. Representative Neal, thanks for sticking around, sticking with us. We are working off of, I've lost every organization. We're working off the version passing the House, LC 481143S. The floor is yours.
Thank you so much. Thank you to the chair. Thank you to the committee. First, I want to make sure you all have the letter of support from the Georgia Chiefs. The police? Okay.
We do.
Thank you so much. So I present to you the House Bill 1054, the traffic signature bill. Originally, this bill was designed to do a few things: reduce negative encounters between law enforcement and citizens, save taxpayer dollars, free up law enforcement for more high priority calls, ensure that everyone goes home at the end of the night. This year alone, we've already started the process to embrace measures like the bill one of our chairmen designed to reduce fingerprintable offenses and step away from taking citizens to jail for lower level traffic offenses. This bill addresses the moment of conflict between citizens and officers on the road, the specific code section that we outline here. Even when I was policing myself, there was a practice that we would use where we would write refuse to sign on the ticket and send them on their way. Currently, the process is you get a ticket, go to court, refuse to sign, you go to jail. What this bill does is you get a ticket, refuse to sign, officer says no problem, refuse to sign, writes refuse to sign on the ticket, and sends them on their way. No more arguments, no more fights, no more instances of officers feeling pressure to risk their lives in an attempt to arrest someone for a lower level traffic crime. Everyone goes home safe at the end of the night. Now, you are not off scot-free. Refusing to sign means that you're agreeing to show up for court. You cannot prepay for the ticket, and if you don't show, you will get a failure to appear by the judge and your license will be suspended. That is a trade-off, but a worthwhile one. Presently, if you get stopped in one jurisdiction and they have this option, you get it. If you get stopped in another jurisdiction and they don't, you don't get it. So what we're trying to do is codify a law that makes it equal across the state. When it comes to saving taxpayer dollars, for instance, if I arrest you for a broken taillight versus taking you to jail for murder, at the jail, the cost per head to the tax dollars is the same, if not more. Those that support this bill feel there's a better practice to reserve the spots in the already overcrowded jails for the more heinous of crimes. Additionally, law enforcement heads have told me we prefer this method. We don't want our officers on the side of the road arguing and fighting with citizens over a traffic ticket. If a citizen doesn't agree, fine, refuse to sign, they go home at the end of the night. All this bill does is codifies into law the ability for law enforcement to write refuse to sign on the ticket where they encounter a citizen who doesn't agree with the charge, and allows officers to take a safer route if they feel it best for themselves and their personal safety. Thank you to my bipartisan co-sponsors, and also thank you to my external supporters, many of which are here today, if you need them. The Georgia Sheriff's Association, Georgia Chiefs of Police, which the letters what you have there, Georgia Municipal Association, ACCG, Georgia Department of Public Safety and the Troopers, they are here as well. Georgia Department of Driver Services, they are here as well. And with that, I will stand for any questions.
All right, thank you, Representative Neal. Any questions for her from the committee? All right, I have one person signed up to speak on the bill, James Woodall, Southern Center for Human Rights.
Mr. Chairman, I was going to say we support the bill as well.
He supports the bill. Don't want to filibuster it. All right, what's the pleasure of the committee? Motion to pass from Senator Redd, a second from Senator Parent. All those in favor, please raise your hand. It is unanimous. Who's going to carry the bill in the Senate?
Senator Albers.
Senator Albers. All right.
Yes.
Thank you very much. Reminder to the committee, tomorrow at 11, different time. We're going to meet at 11 o'clock tomorrow a.m. With that, we're adjourned.